we're here next in People's State of Michigan versus Scott Mills. It's filed 23-6576FH. Counsel, you want to state your appearances for the record, please?
Good morning, Your Honor. Susan Dillon on behalf of the people.
Good morning. This is Jonathan Pyle. I'm here on behalf of Mr. Mills. My partner who initially filed the appearance is stuck in trial today. Thank you.
Okay, very good. And Mr. Pyle and Mr. Mills are appearing by video from separate locations. Either of you can let me know at any time if you need a breakout room to talk. This is defense motion for resentencing or to correct an invalid sentence, arguing that the probation violation sentence was disproportionate. I've reviewed the motion and the prosecutor's response. Mr. Pyle, go ahead with any arguments, sir.
Thank you, Your Honor. Just as the motion had stated, I think everybody's in agreement what the legal standards and tests are here, that we are kind of judging everything against. Here, the real test is the proportionality and whether or not the sentence is basically, if it fits and is reasonable given everything, the circumstances, the offender, the crime itself, is it proportional? Now, the case law, of course, states that the guidelines themselves are just that. They're guidelines, they're advisory, so a sentence can fall below those guidelines. Here, the real rub, the kind of the push and the shove is, it is an unusual circumstance in the way this resentencing or the sentencing came about, in that Mr. Mills was in the program for such a long time. I believe it was somewhere around 18 months prior to being kicked out, and that substantial success and progress he made during that program of having the documented recovery, going through multiple losses. I think he lost somewhere around the 4 or 5 people in his life that were near to him, extreme stress and grief, and he did not relapse and did not use. He, for the first time in his life, had a positive bank account, had paid off all of his fines and fees. The real issue here was a rule violation and kind of behavior that outside of the program rules may have been desirable, in that he was consulting with medical professionals in getting further treatment. Obviously, that was a violation of the rules, which he openly admitted to and pled guilty to that violation. So here, the argument is that this sentence itself, while Mr. Mills does have a significant criminal history, that can be accounted for in the guidelines, and that is the primary kind of driver behind what his sentence is, whereas that doesn't account for the person he became in between the time of the original sentence and when he was resentenced following his removal from the program. So essentially, we would ask the court to grant a new sentencing on the basis that this is an extremely unusual circumstance, so it calls for a sentence significantly below guidelines. Thank you.
Thank you, Mr. Pyle. Ms. Dillon, people's response.
Thank you, Judge. As counsel stated, I think we're all in agreement as far as what the standard is that any sentence nowadays is judged by. But I would say that while we have to apply what's appropriate, the thing is that this was a within guideline sentence, and a within guideline sentence has a presumption of proportionality, or a presumption that it's a valid sentence. And so then the burden would shift to the defendant. They bear the burden of demonstrating that the within guideline sentence was unreasonable or disproportionate. And I understand that we have to look at the circumstances surrounding the offenses and the circumstances surrounding the defendant. And in this case, originally the defendant was actually given a downward departure sentence. He was sentenced to 30 months probation with the recovery court program. The defendant knew going in how difficult recovery court was because he had already failed recovery court before. And this wasn't just the only violation that eventually got his probation revoked. The defendant had violated the terms of recovery court, not just once or twice or 3 times, but at least 4 times. And then he pled to the probation violation, knowing that the sentencing guidelines were 72 to 240 months. He was sentenced to 180 months, which was not at the low end. It was not at the high end of the guidelines. It was still within guidelines. And if you look at it within guidelines sentence and we review it for reasonableness and abuse of discretion, informed by the principles of proportionality, it has to be proportionate to the seriousness of the circumstances surrounding the offenses that were committed and the offenses of the offender. With his sentence being presumptively valid, and we look at the seriousness of the offenses, he committed to and pled guilty to 2 counts of manufacture delivery of a controlled substance. Those are 20-year felonies. He also pled guilty to possession of controlled substance, which is a 10-year felony. And the defendant was sentenced as a habitual 4th offender. The court in this case, I believe, being required to consider the defendant's circumstances, did just that. And the record from the sentencing is clear. The court reviewed several letters of support from several different people regarding the defendant. They listened to defense counsel detail all of the good things that the defendant had achieved, improvements he had made while he was in the recovery court program, and also listened to the defendant. The defendant actually went through his journey, his thought process surrounding the offenses, his time in recovery court, and he asked to be able to stay on probation. And the court also heard argument from the prosecutor as well. I would say that I would argue that this court was very informed of the seriousness of the offenses and the circumstances of the defendant at the time that it rendered its decision. If you look at factors that are referenced in a case like Lampy, which we reference in our response, and you look at what to apply when deciding the proportionality standard, in this case specifically, the offenses are serious offenses, as I already stated, 20-year felonies, 10-year felonies. The defendant, as noted in the sentencing, had 27 prior felony convictions, which if you look at the sentencing guidelines, the variables for prior record variables, the highest you can go on prior record variable 1, which is for high severity felonies, it stops at 3 or more. In this case, the defendant had several high severity felonies, and the defendant did express remorse, but his actions show how long he deceived the recovery court for months. And then you have to look at the defendant's potential for rehabilitation. This was the defendant's 2nd chance at recovery court. He knew how hard it was going to be. He knew what the requirements were. And this court gave him a chance instead of sending him to prison off the get-go, did the downward departure, put him on probation. And then after several months, the defendant seeked out a prescription for Ritalin, something he knew was going to violate his recovery court. Month after month, he went to doctors to get the prescription. He went and got the prescription filled. He then day after day took that Ritalin without disclosing it to recovery court. And this was essentially the final violation that brought him in after several violations for recovery court. It was clear by the transcript and sentencing that the court took everything into consideration. I know at one point this court said that this was a heavy moment for us all. The court then went on to review the highlights for the defendant in the recovery court program, the progress that he had made, pointed out that even though there were violations leading up to the probation being revoked, that the recovery court continued to work with the defendant. But yet the court had no choice but to remove him from the recovery court. And I go back to what the court had stated at the sentencing, that the defendant is not being sentenced for violating recovery court. The defendant is being sentenced for 3 very serious crimes, 2 20-year felonies, 1 10-year felony as a habitual fourth offender. When you take into account the within guidelines sentence, the seriousness of the offenses, and the circumstances of the defendant, given recovery court, then deceiving the recovery court for months, and the steps that he took to continue the deceit and knowing the consequences, the sentence the defendant received of 180 months was within the guidelines. There's no question in regards to the validity of the guidelines in this case. And given the seriousness of the offenses, the circumstances of the defendant, everything that was detailed during the sentencing, the sentence is reasonable, is proportionate when you consider factors that need to be considered for the proportionality. And we would ask that the sentence be upheld and that the motion for resentencing be denied.
Thank you, Ms. Dill. Mr. Pyle, any rebuttal arguments, sir?
Just briefly, Your Honor, I would also state that the legislature, in coming up with the guidelines, they limited the high end of prior record guidelines on all of these grids, and that was a decision they made. So here he ultimately was maxed out on prior record guidelines. So I think the fact that maybe one of the variables didn't fully account for the full picture due to it being concentrated, I would say that overall the guidelines did take into account his prior record. It's just the focus was on that prior record. It's seeming here to ignore the current status of the person who was being sentenced. Thank you.
All right, thank you. Well, the defendant has argued that the sentence that this court imposed of a minimum sentence of 15 years, which was within the advisory guidelines, that's disproportionate to the circumstances. Really, if you read the argument, it seems that the defense is focused on whether the sentence imposed is disproportionate to the circumstances of the probation violation itself. But this argument ignores that the court may also consider the seriousness of the underlying offense for which defendant was placed on probation. There's some of the materials in the written brief which seem to suggest that that's an improper focus, but it is absolutely not. In fact, the probation statute, MCL 771.4 in subsection 5, expressly provides, quote, if a probation order is revoked, the court may sentence the probationer in the same manner and to the same penalty as the court might have done if the probation order had never been made. So when probation is revoked, we go back to sentencing on the original charges. And in fact, in People v. Dykema, an unpublished case in 2017, docket 332905, a panel of the Court of Appeals affirmed a prison sentence after a probation revocation for violation. And in rejecting a similar argument that the sentence imposed was disproportionate, the panel in that case said, quote, defendant's argument on appeal implies that the sentence imposed by the trial court is not proportional to the alleged probation violations, but that argument does not adequately address whether it is in fact proportional to the underlying conviction. Also, a defendant's violation conduct while on probation may be taken into account in sentencing after a probation violation, and the guidelines don't take that information into account. So probation violations can and sometimes do result in an upward departure from the guidelines. For example, see People v. Hendrick, 472 Mich. 555, a 2005 case, a pre-Lockridge case when the guidelines were mandatory, a case that held even then that probation violations could be a substantial and compelling reason for an upward departure under the then mandatory guidelines. So certainly that's true now when the guidelines aren't even mandatory. So we were there to sentence Mr. Mills for his prior offenses, as well as take into account the violation behaviors, and counsel is correct to also take into account the progress that he had made. And in this case, I did state on the record at sentencing why I believe that a sentence just shy of the 2/3 mark of the advisory guidelines was a proportionate sentence, namely that the defendant's underlying convictions were for selling methamphetamine while he's on parole, especially given that this defendant had 14 prior misdemeanors and a whopping 27 prior felonies. There may well be a reason why the guidelines don't take into account how do we sentence somebody with 27 prior felonies, because it just doesn't happen that often that somebody would have 27 prior felonies and still have freedom in any measure whatsoever. In fact, I think many members of the public may be surprised to know that somebody with 20 or more prior felonies may have any measure of freedom in society and is not just locked up for the remainder of their life. And Mr. Mills had been given a treatment court option with downward departures, not once, but twice. And he was nonetheless still violating the treatment court team. That would be an awfully good reason for an upper end of the guidelines, if not a sentence beyond those advisory guidelines. But I did express on the record some of the progress that I believe Mr. Mills had made while on probation. And I did, in fact, take that into account in imposing a sentencing below the upper end of those advisory guidelines. Again, just shy of the 2/3 mark of the guideline range of 72 to 240 months. I continue to, on reflection, still believe that that was a painful day for the recovery court team. It was a painful day for me, and I don't minimize. It was the most painful day of all of us for Mr. Mills, who has to serve the years that were imposed. But it was a sentence that was imposed with much and careful consideration and did take into account Mr. Mills' progress in the program. But I cannot ignore when there's a revocation, somebody being sentenced for selling meth on parole with 27 prior felonies, to go less than the upper end took a great deal of thought and consideration. I think the sentence is proportionate to the seriousness of the circumstances of this offense and this offender. Therefore, the motion for resentencing be denied. Ms. Dillon, as the prevailing party, would the people submit an order to that effect?
Yes, Judge.
And that'll affect Mr. Piles or Mr. Mills' time guidelines on appeal. So we do need to get a written order.
Yes, Judge.
Okay, thank you, Mr. Pyle.
Mr. Gauthier,
Yes, Mr. Mills?
can I just get a breakout room with Mr. Pyle, please?
Yes, absolutely.
Thank you.
Thank you, Your Honor.